Okay, Mr. Blackman,
Morning.
good morning. You're here with Jalen Jackson Wade.
I am, Your Honor.
Have you received discovery yet?
No, I have not. And I talked to Mr. Dobry yesterday, and we talked about that, and he was going to be emailing me or getting with me on the discovery. That's why we're asking for an adjournment of the.
Okay, we have a preliminary examination date for the 7th. We can treat that as a new probable cause conference, and then we'll address the timeline then. And I just signed the substitution.
Thank you. That would be great.
You're welcome. So you're all set for today.
Thank you, ma'am.
No problem.
Hello.
Okay, and Ms. Donnelly, I think you were here on Elaine Edwards.
Yes, I also have Sanquita Callahan.
Okay, I do see Elaine Edwards here, and Sanquita Callahan both.
I'm ready to go with Ms. Edwards. I need to speak with Callahan.
Okay. Who's in the jail?
Who is the wellness?
Okay. And then Mr. Abbott, I think just stepped out.
My case, Your Honor. Good morning.
Good morning. You said, do you need to speak with him?
I do, Your Honor, if I may, briefly. Thank you.
Jail and vital signs.
Thank you, Your Honor.
No problem.
I mean, I haven't watched the video, but I understand. Yeah, but she also.
Mr. Abbott, who did you need to speak with?
Deanna's Lee.
Okay, one moment.
She denied. Yeah. Yeah, yes, yeah.
You say you were ready on Callahan?
I have to speak to Callahan, Ray, and Edwards.
Okay, on the record in the matter of the people of the state of Michigan versus Elaine Michelle Edwards, file number 23-03508. Council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Elaine Edwards, who's appearing separately by video.
Ms. Edwards, can you hear us?
Yes, ma'am.
Okay, today was the date and the time that was set for probable cause conference on one count of assault with a dangerous weapon. This matter is scheduled for preliminary examination on December 7th at 8:30. There was an offer extended, it looks like, for the defendant to plead to an added count 2 of disorderly jostling. How are we proceeding at this time?
Your Honor, we'll just leave it on for preliminary exam, and Ms. Edwards will consider the offer as well.
Okay, we'll continue to examination. You'll be in person next week, December 7th at 8:30. Okay, Ms. Edwards?
Yes, ma'am.
Do you have any questions?
No, not at this time, Your Honor.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, for defendant.
You're all set. Thank you.
Thank you.
You need me to put you in a room with.
I'll get on Zoom, yes.
Okay. Ms. Wanji, you're here with Mr. Coleman.
I am, Your Honor.
Are you ready?
I am.
On the record in the matter of the people of the state of Michigan versus Dustin Walter Coleman, file number 23-03542, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Well, everyone, Chief for Mr. Coleman.
Mr. Coleman, can you hear us? I don't think you can hear us. You cannot hear us. Mr. Abbott, are you ready on Ms. Lee?
Yes, Your Honor.
Okay, I can't see her.
Yeah, she's all fogged up. She says the camera on her phone is broken. She's not in jail anymore. She's out.
Okay, well, then she can appear in person if the camera doesn't work.
Okay.
Okay, Mr. Coleman,
All right.
can you hear me?
I can hear you now. Can you hear me?
I can hear you, thank you.
right, let's go.
Today's the date and time that was set for probable cause conference. Mr. Coleman, I have one count of assault with intent to do great bodily harm less than murder or by strangulation, and account 2 of domestic violence, second offense notice. The matter is scheduled for preliminary examination in person at the court, December 7th at 9 a.m.
Correct.
Are we proceeding to prelim?
Yeah.
Okay. Okay, and it looks like there was no offer at this time. It's the people's intention to run the exam, correct?
That's correct, Your Honor.
Okay, I'll note that in the file. Do you have any questions today, Mr. Coleman?
No, I do not.
Any additional matters for the record, counsel?
No, Your Honor. Nothing.
Thank you, you're all set. Ms. Lee,
Yes, ma'am.
you can appear in person because we can't see you.
Well, do you want me to turn my camera around? Hold on. Oh my gosh. Hold on. How do I do this? Is that better?
That is better, thank you. On the record, in the matter of the people of the state of Michigan versus Deanna Lee, file number 19-04332, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott, representing Ms. Lee. She appears by video today.
Okay, Ms. Lee, today was the date and time set for sentencing. I did not refer her to probation, I don't believe. I don't have, at least I don't have a file from probation.
I did not receive a pre-sentence report either, Your Honor. So
I do have a victim impact statement. Are you anticipating reading that into the record?
No, I was not, Your Honor. I did have contact with the victim yesterday. I'll just briefly say his main concern was restitution in this matter. Otherwise, he would leave sentencing to the court's discretion. He will not be appearing today.
Okay, Mr. Abbott, you received a copy of this file with the restitution amounts?
I have not, Your Honor. But I spoke with Mr. Brodowitz this morning, and I did speak with Ms. Lee this morning, and she understands there's a restitution to be paid.
Okay, well, does she understand the amount?
I don't remember the amount.
I think.
Okay, I have here from the victim impact statement that they're alleging an insurance deductible of $53.34. Is that accurate? Is that accurate?
Yes, Your Honor. If I may, I have a total that was,
Okay, but I'm gonna go through the itemization since he says he didn't get these receipts.
okay.
Okay, and then there's a homeowner insurance of $50. It says lost damaged property, $227.39. And then lost wages of $165, not documented. Is what it says in quotations. I see Northside Towing here. A receipt for $185. I don't see that on this itemization. Did I miss this somewhere? And the Riley Auto Parts, what are those for? What are these receipts for? Do we know?
I believe there may have been some damage to the car, Your Honor.
Okay, so this was not something that was covered by insurance. Is that what you're saying?
I believe so, Your Honor. That was the restitution that was, and like I said, I have a total amount that was established at the beginning of this file back in, I believe, 2001, which was part of the plea agreement.
Okay, let's see here. Okay, I'm gonna read the victim impact statement. It says, to steal my car, the defendant had to take my key ring, which included not only the key to my car, but the key to my apartment and the key to the door of the restaurant where I work. The defendant also took my wallet, which of course had my driver's license, bank, and credit card. So I had no ID, no money, no way to get money, no transportation. My home and workplace were vulnerable. I was in a panic and great stress for several weeks. It takes time for all of these things that could be replaced to be replaced. The locks to my apartment and workplace had to be changed. I had to get new credit cards and a license. I had to miss work to take time to deal with everything, which was a great stress. It says, I will be disappointed if the defendant is not sentenced to jail time. Okay, let's see. What's the total amount?
The total amount, which I believe was part of the plea agreement last time we were here, was $633.73.
Okay, is there any objection to that amount of restitution?
No, Your Honor.
Okay, you can make allocution.
Thank you, Your Honor. Ms. Lee is, I believe she spent 48 days in jail on this so far. She's also in a situation now where she'll have to pay back this money. She understands that. She's talked to me about her intention to do so. I'd ask the court for time served and only probation necessary to collect the funds that she owes. Thank you.
Okay, and this is a matter that allegedly occurred back in 2019. Since that time, again, as you indicated, the defendant has served about 43 days in Ingham County Jail. So that will be the sentence of the court, 43 days Ingham County Jail, credit time served, order of restitution in the amount of $633.73 plus $75 crime victim rights and a $50 state minimum cost. Ms. Lee, when are you going to make your first payment?
I will probably next Monday, I'll come in and make it. Where do I have to make the payment at? Do I have to come to the courthouse? Okay.
That's correct.
Okay, ma'am. Yes.
Okay, what day next week?
Monday, I think that's, what date is that? I'm looking at the calendar, so that's the 4th.
How much
December
you gonna
4th.
pay in the fourth?
It may only be like $50 at a time because I'm not working right now. I'm trying to get my disability, so I'll just start making payments on it as much as I can.
Okay, I'll note that you'll make a payment of $50 on December 4th, and you'll make a payment of no less than $50 per month on the 4th of each month until paid in full.
Okay.
You have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you, Your Honor.
Thank you, you're all set.
All right, have a good day.
You too.
Did I fill out a restitution sheet?
You did not.
Okay, we'll have that done. Just.
How do I exit out of this?
I can remove you,
Okay, thank you.
no problem. Mr. Feigelson, okay, are you ready to go on the record?
Yes, Your Honor, thank you.
On the record in the matter of the people of the state of Michigan versus Luis Angel de Huelves, file number 23-03533, council appearance.
Yeah, Prado, it's on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson appearing on behalf of Luis Delavez, Your Honor, who's present by way of Polycom from the Ingham County Jail this morning.
Okay, and this is Mr. Luis Angel de Huelves Jr., correct?
Yes, Your Honor.
Okay, today's the date set for probable cause conference. I have one count of home invasion, first degree, and count 2 of assault with a dangerous weapon. This matter is scheduled for preliminary examination next week, December 7th at 9 o'clock in the morning in person at the court. Are we continuing to exam?
Yes, we are, Your Honor.
Was there an offer on this?
Yes, there was, Your Honor. At the time, when I was sending these out, we did, and I'll just put this on the record, we had received, Mr. Feigelson's appearance that was sent to our office on the 22nd. It was not uploaded into our system until the 27th. And I do not believe Mr. Feigelson, has received discovery yet. I have sent an email this morning to our discovery unit to make sure he gets that. The offer, which I relayed to him this morning when I spoke with him, was for Mr. Duhaldes to plead to an added count 3 of aggravated assault. People would then dismiss counts 1 and 2.
Is that correct, Mr. Feigelson? You didn't receive your discovery yet?
That's correct, Your Honor, and I did get the offer, and I had a conversation with my client about that offer, and for right now, I wish to leave the matter on for an exam.
Okay, so we'll continue to exam. We'll see everybody in person on December 7th at 9 a.m. Do you have
Thank
any
you, Your Honor.
questions? No problem. You have any questions, sir?
No, Your Honor.
Okay, you're all set.
I'll talk with you early
Thank you.
next week, sir. Thank you.
Who's representing Alexander Priest?
I am Your Honor, Jennifer Weesey, P66162.
Okay. Get a substitution.
Yes, Your Honor, thank you very much. My understanding is we were just retained on this file and are filing our appearance in demand and substitution. The request is for a waiver of the 21-day at this time and to set the preliminary exam at a later date than December 7th so that we might have time to review discovery.
Okay, because we haven't received a substitution of counsel yet, nor have you officially filed for your discovery demands, I'm going to go ahead and treat next week, the 7th, as a probable cause conference. And then we will address the timeline then and set a new date for the exam.
Thank you, Your Honor. Can you let me know who his current attorney is, if you know?
Aaron Robinson.
Thank you so much.
No problem. And then I do have here a PA 53 bond violation here. Let's see. The allegation in the report that you violated the no contact order set by Magistrate Millmore on or about November 25th, 2023 at approximately 10 o'clock. In addition, that no contact order prohibits you, Mr. Priest, from having contact directly or indirectly with a Deshonda Stevenson. And the allegations are that you did violate that. So you have the right to have a contested hearing on the bond violation. You have the right to be represented by your attorney at that hearing. And you have the right to have evidence brought forth to establish beyond a reasonable doubt whether or not you violated your bond. If it is determined that you have violated your bond can be revoked pending this matter being resolved. You also could be sentenced to a contempt of court for the violation. Contempt of court is punishable with a maximum penalty of 93 days in jail and or up to $7,500 in fines. Do you understand that?
Yes, Judge.
Okay. For the purposes of his arraignment on the bond violation, does he want to plead not guilty?
Yes, please, Your Honor. And if we could set it for December 7th, that would be perfect.
Okay, we'll set the PA 53 hearing for December 7th at 9 a.m. Any additional matters on today's record?
No, thank you.
Thank you. You're all set for today.
Thank you.
Thank you. Did Ms. Wanji speak to Mr. McDadden already? I don't know what she wants to do because he is here. Are you ready with Ms. Callahan?
I am, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Sanquita Callahan. File number 23-03029. Ms. Callahan, please start your video. There you go. Council appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Sanquita Callahan, who is appearing separately by video.
Okay, Ms. Callahan, today's the date set for a probable cause conference. This matter is scheduled for preliminary examination next week, December 7th at 8:30 in the morning on one count of child abuse in the third degree, count 2 of domestic violence, and a habitual offender third offense notice. Let's see. Offer from the prosecutor's office is for you to plead guilty to count 1 as charged, and the people would dismiss count 2 and the habitual offender notice. Counsel, how do you want?
Your Honor, at this time, we do have our discovery and we would like to leave it on for preliminary exam.
Okay, so we'll continue to examine. Ms. Callahan, you will appear in person next week for your preliminary examination, okay?
Okay,
Do you have any questions?
no, ma'am.
Any additional matters for the record?
Nothing from the people, Your Honor.
Yes, Your Honor. One thing, Ms. Callahan, for her bond, there is currently a no contact order set with her daughter, the complaining witness. When this CPS was involved in this case back when it was filed in May, it's my understanding I contacted her caseworker, Bob Siegel, and he told me that the case had been closed for several months and that CPS never removed the children from the home, and that Ms. Bowser was living in the home when Ms. Callahan was arraigned. We would just like the court to consider amending the no contact order so that, because right now she's the only child that's having to stay outside of the home. If there's anything that the court would consider in amending the no contact order.
Ms. Broderick.
Yes, Your Honor, the people would just ask that the order remain in place, at least until the time of the preliminary examination, as this is a child abuse matter, along with a domestic violence situation. People would ask that the no contact order remain in place.
Oh, just so you know, Your Honor, we're not asking for the domestic violence concerns another, her mother who doesn't live in the home. We don't have no issues with that no contact order right now.
I think that the no contact order as it relates to the minor child is appropriate pending these concerns regarding count 1 of child abuse in the 3rd degree. That's the best way to proceed to avoid any witness tampering or other issues. It's very typical to have a no contact order in place of this kind. So the no contact order will continue as such. Any additional matters for the record?
No, Your Honor.
Nothing.
You're all set, Ms. Callahan.
Thanks.
Mr. Jehuelvis, you were all set.
Okay, thank you.
You're welcome. Ms. Swanji, are you ready with Mr. McFadden?
Sure.
I am, but Mr. McFadden, I don't know why he is.
He's on Zoom.
Oh. I did talk to him yesterday, so we're going to leave it for next week.
Mr. McFadden, can you hear me?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Ralph McFadden, file number 23-03362, FY council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
May I need one for Mr. McFadden?
Okay, this matter is scheduled for a preliminary examination on December 7th at 9 o'clock in the morning on weapons carrying concealed, weapons firearm possession by felon, weapons felony firearm, and an habitual offender 4th offense notice. And we're continuing to examine, is that correct?
That's correct, Your Honor.
Okay, and then I have, it appears, multiple GPS violations, it looks like. Wow. I believe that the first issue from November 14th about the electronic monitoring device being cut off was resolved. Mr. McFadden appeared in the court earlier this week, and we directed him to contact his 2 attorneys at the public defender's office.
Yes, Your Honor.
Explained he had gotten the tether issue resolved. Is that correct, sir?
Yes, Your Honor.
Okay, so the violation in my file from the 14th will be dismissed. There was a violation from November 28th indicating that Mr. McFadden entered the exclusion zone at 11:08 a.m. He drove through the zone and exited at 11:09. Where were you heading, sir?
I called the tether people. I told them I was with my grandma helping her out, and she was taking that way to her house. And I told her, like, this is not the way, and she instantly got her off the street.
Okay. Yeah, we were only in there for a short period of time, so we'll dismiss that violation. Looks like similar violation, same date, 11:34 to 11:35. You were, I'm sure, in the car with your grandmother still.
Yes.
Then again, there was a violation yesterday, that you entered the exclusion zone 11:25 at 12:25 PM until 12:26 PM.
The where I stay at, like the exclusion zone is kind of like 2 blocks like from like my like location, like where I stay at, like the way I have to get to my house, like currently, like, and it's like
Where do you stay?
like where I tell you that is 3031 in South Washington, and the exclusion zone is around like Cedar and like the back streets of the area I'm in. I stay like on Holmes and Washington, like at like kind of the corner.
Each violation was about a minute long. I'm gonna dismiss it. You know what the exclusion zones are, so be careful, so that you don't end up with a violation that we need to move forward with, okay?
Okay.
Do you have any questions?
No, Your Honor.
Any additional matters for the record?
No, Your Honor, thank you.
Nothing from the people, Your Honor.
You're all set, Mr. McFadden. We'll see you next week in person.
Okay.
Thank you, Your Honor.
You're welcome. I think we did Wade. We did. Jalen Wade, you're all set.
Okay, I just wanted to make sure because when I came in, I thought y'all was wrapping up, but y'all didn't. Nobody said if it was me or not. All right, thank you.
Yep, your attorney, you'll come next week. We'll treat it as another probable cause conference.
All right, so the 7th, right?
I'm sorry?
On the 7th?
On the 7th, that's correct.
Okay. All right, thank you. Have a good day.
You too. Did I see Kyla Marshall? I don't think I did.
No.
If, Your Honor, Ms. Mark was represented by Attorney Dan Doyle. He was here today. He did also send me, he replied to the email I sent out yesterday with the offer to me and Ms. Nash, stating he would like it left on for preliminary exam.
I don't have a substitution.
No, that was, I spoke with attorney, and I don't know if you want Mr. Doyle here, if he's still here.
If he could enter, if he's still here, that'd be great.
I did both my head up.
You just need to, as a substitution.
I believe it's coming, Your Honor.
Oh, okay, that's fine, then we'll
Okay,
just
yeah,
continue.
I spoke with Attorney Erin Robinson yesterday. She said she signed it and sent it back to his office, so I believe it's coming.
Okay, continue.
Then I can forward it to
Very good.
your staff, just so you can.
Is that all of the probable cause conferences? I believe, and I think I don't have anything else until 10. I think I have a meeting right now, though. Okay, I see Alice Pye.
Yes, yes, Your Honor. Alice Pye, representing the landlord, Affordable Rental Management.
Okay, this is a matter of Affordable Rental Management LLC versus Zara Kumi, Dahlia Galal, and Diana Kauta. Let's see, I have that this was a motion for leave to amend, but I think this is supposed to be for a escrow order. Is that correct?
Yes, that's correct, Your Honor.
Okay, and you are seeking an escrow order. There's an amount of unpaid rent, $8,610. Plaintiff, they have difficulty in locating the defendants to recover the amount owed, especially when the defendants failed to appear to court for at least 2 times. I will note that they failed to appear again today as well. You are seeking to have an order entered whereby they will deposit $8,610 for prorated rent from the date of this, the next rent date. That's the past due amount of the rent at this time?
Yes, Your Honor, that's the accurate amount because the tenant has already moved out from the premises.
Okay, I will grant your order in the absence of the defense counsel or their client with any objection. So I sign it for and date it for today, and they will be ordered to place that payment within the next 7 days. Any additional matters for the record?
Thank you, Your Honor. Yes.
You're all set then.
Are you going to rule on the leave to amend as well?
Oh, there was a motion.
Yeah, we would like to request to add the items for damages under Section J of the complaint.
Sorry, I'm trying to find. I need to find this motion. You said it was a leave to amend.
Yeah, I believe
it's to amend the complaint.
It's to amend the complaint. Yes.
Due to the substitution of attorney by the plaintiff's new attorney in the plaintiff's behalf, the party was making moves to amend the complaint initially filed by adding the following damages to the J section of complaint: $50 late fee per month, an attorney fee, security deposit, fund, court costs, property, clean, and repair costs. That's what you seek to amend to add?
Yes, Your Honor.
Okay, your motion is granted.
Thank you, Your Honor.
Thank you.
Sorry, Your Honor, please. Sorry for the interruption.
You had another question?
Yes, may I request a default judgment be issued? Because the defendants and their counsel, this is not only Tom, both of them are absent from the court.
Okay, what is this? So I see a subpoena in the file. I'm just making sure there was a notice for them to appear today. I do see this matter is set for jury trial on the 10th.
Your Honor, they failed to appear. Yes, Your Honor.
Okay, I see a certificate of mailing back on November 17th, indicating that they were supposed to appear today, no later, by 10 o'clock for today's hearing, and they failed to appear.
Yes, Your Honor.
Your motion to default is granted.
Thank you. So we'll file the default judgment as a result of your decision today.
Okay, thank you.
Thank you, Your Honor.
You're all set.
Thank you.
Thank you. Okay, which matter are we here for here? Are you here for Woodside?
Yes, sir.
Okay, Woodside Meadows Apartment versus Bernard Greer, file number 23-02145 LT. Council appearance.
Sorry, Your Honor, Mike Zappin, P68-107 on behalf of the plaintiff.
Okay, and what's your name, sir?
Bernard Greer. Your Honor.
Okay, Mr. Greer, you can have a seat.
Thank you.
Okay, and so this matter was adjourned. At our last hearing, you indicated to the court there, the property was pink tagged, and you were waiting for an inspection.
Yes, ma'am.
And that you said there were some habitability issues,
Yes, ma'am.
and that you had put in a maintenance request. The parties have a discussion today at all?
Defendant refuses to talk to us, so.
Okay.
That's not true. Your Honor.
Okay, well, I see here that you did file an answer on November 20th. Supplemental answer to complaint, affirmative defenses, and counterclaim was filed. Your office received that?
No, we did not, Your Honor.
Okay, that was filed on the 21st. Did you serve him with a copy?
I tried to serve him today, ma'am. He refused to receive it. I haven't got it.
I'm sorry?
He gave me a copy this month when he came in court. You know, I gave Miss Melinda a copy. When I tried to give him a copy, he refused to take it from me because he said I had the 22nd to give it to me, which I explained to him. And I had the 22nd to give it to the courtroom. And I thought I was under the impression that I had to today to serve him.
You were supposed to serve him before today's date.
My apologies, sir. Ma'am.
Okay, you have a copy you
Yes.
were received, you provided today?
Yeah, I have a copy. I don't think I'll defer to the court. I don't really have an objection to anything here because it kind of helps our case, to be honest with you.
Okay, a supplemental answer and complaint essentially indicates he doesn't have the plaintiff does not have a right to the property because the reasons stated in the answer and the defense and counterclaims. What is the counterclaim?
Since March to April, they have violated the lease by overcharging.
Okay, I just see a counterclaim and there's no other page. It says the parties to the lawsuit are also parties to a lease that have been attached to plaintiff's complaint. Plaintiff has breached this lease in a manner described in the affirmative defenses. I have been denied the benefits of a fully bargained contract. I have been damaged in the form of time, money, and inconvenience. But you haven't indicated in this what the breaches were. And you need to indicate what the breach is.
My apologies.
The other thing is, it says State of Michigan 56A District Court, County of Eaton, and that's the wrong header, just so you put it. This is 54A District Court, Ingham County.
Yeah, and when I downloaded this from the system, it had that cross out at the top of it. And yeah, I don't know if your copy got it.
I'm talking about your supplemental answer to the complaint that you filed.
Apologies, I didn't realize that. Entered the wrong information. Well, because I live in Eaton County, I assume that that's where I was supposed to address it.
No, this is the 56, this is not the 56A District Court, this is 54A District Court in Ingham County. This is what I'm telling you.
Okay.
Okay.
My apologies.
Okay, and so you have filed this complaint in what you say is affirmative defenses.
Yes.
Where are the affirmative defenses?
I have a back door. That's number one. That
There,
is-
you have this in writing. I don't want you to.
Yes.
Where,
Well,
where I'm
it's
looking,
in
where
the-
page?
Well, it's in these. I didn't know that I was supposed to put it in this. I'm
Yeah,
sorry.
you have to plead your affirmative defenses. You have to also plead your counterclaim. I mean, you put it in writing. You tell us what it is.
Oh, in detail.
Correct.
My apologies, Your Honor. I'm still trying to learn this process on my own.
What you have in your hand appears to be a proposed exhibit, not an affirmative defense.
I don't know what that means either. This is with the,
Is that something from the City of Lansing Code Compliance?
yes,
So that would be something that you would later want to enter as an exhibit to
Okay.
support your claim that there was a breach or to support any of your affirmative defenses.
okay,
But that's not you pleading your affirmative defense. You gave me a header that says you have supplemental answers to complaint, affirmative defense, and counterclaim, and then you never put counterclaim or the affirmative defense.
I guess I thought I was just going to present that here today. I'm sorry.
That's not what today's date is for. Today's date was set for a hearing. And if you're going to file your answer and a counterclaim, they have a right to respond to your answer, to your counterclaim. They have to answer your counterclaim, but they've not received notice or the counterclaim. What they received there is the same thing I have in the file. It doesn't tell me what your counterclaim is.
I'm sorry, I'm lacking on the details. You know, I'm still learning this process.
Okay, do you know what a counterclaim is? Because you said you were gonna file a counterclaim.
Yeah, I thought I
It
did.
means that you want to sue them for something.
Yes,
So you have to place in writing, and you're supposed to do it according to the court rules, to indicate to them what it is specifically that you're suing them for, so that they can be placed on notice. What you're telling us is you're alerting us to a affirmative defense and a counterclaim. We don't see what that is.
yeah, I'm not,
An affirmative defense is, I shouldn't move because there was a breach of habitability. That's not here. I don't see anything here that tells me what your affirmative defenses are or your counterclaim.
yeah, because I thought I was going to be presenting that today, ma'am.
Nope, that's
My
not-
apologies.
You're not gonna be presenting that. You're gonna put it in writing.
Right,
And you're gonna file a copy with the court, but you serve a copy on them. And you serve it on his or her attorney. You don't serve it on her. You understand that?
I do now, yes, ma'am.
Okay. Because all I see from this filing that you just served the plaintiff's attorney with is a motion for more definite statement, because there's been nothing definitive here to let them know. I believe your answer, I guess, is sufficient. But your counterclaim and affirmative defenses is where you're lacking in this pleading, okay?
Okay. I do apologize, ma'am. I'm trying to learn as fast as possible.
I recognize you're trying to navigate this on your own, and so. You were already in contact with legal services, is that correct?
Yes, and they told me they cannot help me because my wife makes too much money.
Okay,
So they gave me a number to, that's name, but he has not responded to my phone calls or my answer. Well, he did respond once to answer machine message that I left him, but I have been unable to get back in contact with Mr. Oh, I know his name. That was given to me by legal services.
okay.
Which I believe his office is in here, which I will stop by today and see if I can.
Okay, and I have your answer here. You did not make a demand for jury, correct?
Correct.
Okay. And so we'll proceed with a hearing on this, or were you looking for a non-jury trial?
Oh, whichever, I'm not sure how to answer that, ma'am. If it has to go to jury, I'll go to
It does
jury.
not have to go to jury. You did not. I'm just noting your answer. The number one is I demand a jury trial. That was left unchecked. So that
Okay.
means that you're not demanding a jury trial.
No.
We can resolve this by way of a hearing then.
Yes,
And then you need to file a new affirmative defense and counterclaim if that's your intent, because this
yes.
doesn't tell us what it is.
I apologize.
I'm giving you 7 days to do that.
Thank you, Your Honor.
And your office is in Flint?
Yes, sir.
Okay, can you provide him with maybe an email or some way that he can, I guess, or he can mail you the pleading once he's amended it?
It's Sabrina. I really know. Is that the same one on the website? Because you can't post nothing and send nothing to that. Sabrina. Can you spell that for me, please, sir? SAB. And Piper. Pipper. Legal.
If you have any questions and numbers, you can give us a call if you have any problem getting that to us. The number is 810-235-2558.
2558. Yep. Thank you, sir. And your name, are you Art Piper?
No, I'm Michael Zappa.
Michael. Can you spell that last name for me?
SZA-PPAN.
The AI?
AN.
SZAPP. Thank you very much, sir. I'm adding to this in great detail.
Yeah, you need to, the things that you think that they did to cause you to be able to sue them, you need to put it in writing.
Okay.
So that you can put them on notice as to what you're suing them for.
They changed their residential portal. So up until, I don't know, maybe 4 months ago, I was able to access all the information and get back all the information that was onto the residential portal about rent, late, and time and dates.
Okay, so you're saying you don't have access to some of the documents that you need?
Yes, ma'am.
Okay, you can subpoena them from them.
Okay.
You can let the attorney know what you need. Okay?
Yes.
We're willing to comply with any request.
Yeah, you make a request via email to him. He said he's willing to comply, okay?
Thank you, Your Honor. Yes, thank you.
We would just ask for an escrow grant effective December 1st. I don't know if you want that already, but we had a total amount of rent due at 96,2783. I understand there's a pink tag issue, but that pink tag really states that they have two options to pay the rent to the landlord or to escrow with the court. So we just ask for an escrow order.
I'm going to grant an escrow order, and you need to be placing your rent in escrow with the court, okay?
I was told that all we could leave.
Have you left?
No, because that's when I entered the county.
Oh, okay, okay. Well, how much is his rent monthly?
Well, he's disputing that. It was normally $1,000, but I do have notice that has not been going up to $1,100 because you get the lease. I do have that copy. And that was effective April
of this year?
April 1st.
Okay, they have not offered a lease. And when the lease was signed in 22, it was $4,000. And since then, that pink tag, they don't have a lease to offer. How can
Okay,
you still offer leases?
what are you all, if you all want to have a private conversation, you can do that later. You said that the rent went up when?
April 1st, I have a document. It was emailed to Mr. bdcareer@yahoo.com on March 15th, indicating that his rent would go up if he didn't sign a new lease. He did contact the agency. If the rent was $1,000, it went up $100 since the lease signed.
They've been charged me that since I signed the lease last year. It's one of the violations of our lease.
Better to simplify things. We'll go with $1,000 for escrow.
Still
Okay, you're December 1st, which is tomorrow. You need to be placing $1,000 in escrow.
Okay.
At the court.
Up here?
That's correct.
Okay.
You'll place your rent in escrow every month on the 1st.
Okay.
Can you get me an order?
Yes, sir.
Okay. Okay, and then you have 7 days from today to file your new or your amended affirmative defense and counterclaim, and then you will serve them with a copy of that filing, meaning you're either going to mail it or email it to him, okay?
Understood.
Do you have any questions?
No, ma'am. Does it take time to set up escrow, or is it something that can be done in one day?
When you leave or go down to the 5th floor to the civil department and you can get information about how you set up escrow there, okay?
Thank you.
Any additional matters?
None, Your Honor.
You're all set for today. We'll get you a notice for your next hearing date in the mail.
Thank you. Thank you. That's for over to this one.
Thank you.
Thank you.
Thank you.